We've got some major developments to talk about today regarding efforts to eliminate the remaining restrictions on suppressors under the National Firearms Act. A brand new federal lawsuit has just been filed, aiming to overturn state-level bans on suppressors. This legal action comes directly in response to recent changes passed through the Big Beautiful Act, where the NFA tax on suppressors and other NFA items was reduced from $200 to $0. Let's break down exactly what's happening. If you've been following recent legislative activity, you'll know that H.R. 1, commonly referred to as the Big Beautiful Bill, passed with modified versions of the Hearing Protection Act and the Short Act included. Unfortunately, while those bills originally sought to remove items like suppressors and short-barreled rifles from the NFA entirely, what we ended up with was a tax cut, not full deregulation. Now, under the new law, the $200 tax stamp requirement has been completely removed. That means individuals no longer have to pay a tax to acquire items like SBSs, SBRs, any other weapons, and suppressors. It's progress, but let's be honest, it's a half measure. A big reason for that is the lack of willpower from establishment Republicans in Congress. Many were unwilling to challenge the Senate parliamentarian who struck out the stronger language from the final version of the bill. As a result, the only change we got was the elimination of the tax, while the items themselves remain on the NFA registry. But this fight is far from over. Following the passage of the zero tax provision, multiple lawsuits have been filed across the country challenging what's left of the NFA restrictions. One such lawsuit, brought by Gun Owners of America, Firearms Regulatory Accountability Coalition, Palmetto State Armory, and Silencers, was filed in the Northern District of Texas. That lawsuit specifically targets the ongoing registry requirement, arguing that if there's no tax, there's no constitutional basis for the federal registry to continue existing. And now a second lawsuit has been filed, this time targeting state bans on suppressors. This case was filed in the state of New Jersey, where suppressors are still completely banned. The plaintiffs in this case include the Second Amendment Foundation, the Association of New Jersey Rifle and Pistol Clubs, the American Suppressor Association, ASA, and the NRA. The case is titled Padua v. Platkin and has been filed in a federal district court in New Jersey. The lawsuit challenges New Jersey's blanket ban on both the purchase and possession of suppressors, arguing that this prohibition is unconstitutional. The plaintiffs are using the recent changes to the federal tax requirement as part of their legal argument, claiming that if the federal government no longer treats suppressors as taxable, states have even less of a basis to outlaw them altogether. In their complaint, the plaintiffs assert that the Second Amendment guarantees peaceable citizens the right to possess common arms for self-defense, protection of family, and other lawful purposes, including the use of suppressors. They also cite a recent federal court case from the Fifth Circuit, U.S. v. Peterson, where the Trump DOJ acknowledged that suppressors fall under the protections of the Second Amendment. In that case, the Department of Justice explicitly stated that suppressors are constitutionally protected arms. Therefore, states that continue to enforce outright bans on these devices are violating the constitutional rights of their citizens. In this lawsuit, the plaintiffs argue that the federal government itself has acknowledged that outright bans on suppressors, like the one in New Jersey, would violate the Constitution. They go further to assert that New Jersey's law directly implicates the plain text of the Second Amendment. By banning suppressors, the state is effectively banning suppressed firearms, and suppressed firearms are still considered arms. The plaintiffs emphasize that suppressors play a legitimate role in self-defense. They enhance a firearm's effectiveness and reduce the risk of hearing damage during lawful use. Because of their integral use with firearms, federal law has long treated suppressors as arms under the legal definition. So when New Jersey prevents its citizens from owning or carrying them, the plaintiffs argue that the state is essentially blocking their ability to keep and bear arms, something the Constitution explicitly protects. Under this interpretation, for New Jersey's law to stand, the state must prove that its ban aligns with the nation's historical tradition of firearms regulation. According to the lawsuit, the state simply cannot meet that burden. They also stress that suppressors are clearly in common use across the United States. Despite New Jersey's restrictive stance, 42 other states allow law-abiding citizens to legally own and use suppressors. The plaintiffs note that suppressors have been legally owned and used in America for more than a century. To legally possess a suppressor under federal law, individuals have traditionally had to register the item, submit fingerprints, and pay a $200 tax. But with the recent passage of the new legislation, often referred to as the Big Beautiful Bill, that $200 tax has now been eliminated. Starting January 1, 2026, that tax will be reduced to $0. The plaintiffs argue that this change significantly weakens the legal foundation for any remaining bans, especially at the state level, and opens the door to new legal challenges like this one. The lawsuit also highlights that suppressors aren't just common in the U.S., they're widely used around the world. In fact, many countries impose little to no restrictions on them. This global acceptance adds weight to the argument that suppressors are neither dangerous nor uncommon. Finally, the plaintiffs ask the court for two specific outcomes. First, they request a formal declaration that New Jersey's ban on commonly owned suppressors and all related rules, laws, and enforcement policies violates the Second Amendment rights of law-abiding citizens. Second, they want the court to issue an order preventing all relevant government officials, law enforcement officers, and agencies from enforcing New Jersey's suppressor ban in any capacity. In simple terms, the plaintiffs are asking the court to strike down New Jersey's suppressor ban, arguing that it clearly violates the Second Amendment. They also want the court to issue an order that blocks the state, including law enforcement officers and government agencies, from enforcing the suppressor ban in any form. This lawsuit represents a major challenge. We've already seen organizations like Gun Owners of America file legal actions in Texas federal courts, aiming to remove the remaining registration and tax requirements under the National Firearms Act, especially after the $0 tax provision was signed into law. Now, with this case, other prominent organizations, such as the Second Amendment Foundation, NRA, and American Suppressor Association, are targeting states like New Jersey, where suppressors are completely prohibited. They're asking the court to take another look at whether states have the authority to impose total bans on suppressors. And their argument is simple. Completely banning suppressors is unconstitutional. What's interesting is that this appears to be part of a broader, two-pronged legal strategy in response to both the $0 tax change and the passage of the so-called Big Beautiful Bill. The first prong targets the tax and registration side of suppressor regulations, and the second challenges the outright bans enforced by some states. It wouldn't be surprising if we see more lawsuits like this filed in other states in the coming months. In fact, we may also begin seeing similar legal challenges against state bans on short-barreled shotguns, using the same argument. The change to the NFA tax weakens the foundation those bans stand on. This could pave the way for lawsuits in several other states that continue to criminalize possession of these items. This is shaping up to be a very solid and strategic legal case. Now all eyes are on the court to see how it will respond. It's also expected that the Trump DOJ may get involved in support of these challenges. They've already indicated in other cases that states cannot impose blanket bans on suppressors. We've seen them file supporting briefs in lawsuits targeting bans on so-called assault weapons, rifles, and standard capacity magazines. Their stance has been consistent. Statewide bans like these are unconstitutional. And if that pattern holds, we may see the Trump DOJ step in once again in this new legal battle over suppressors and SBS bans. So, this case, filed in direct response to the passage of the $0 tax and the federal reforms in the Big Beautiful Bill, is another major move in the effort to roll back excessive firearms restrictions at the state level. As this lawsuit moves forward, I'll keep you updated with all major developments. If you found this update informative and want to support the channel, the best way is to subscribe. Your support helps us keep covering these critical Second Amendment issues. As always, thank you for watching.